Lords, I had just finished the authorities and I was moving on then to respond to the claimant's second ground of appeal.
Right.
And I'll begin, if I may, with the Tribunal's decision on this issue. And the Tribunal's judgment, as you know, is in the core bundle, tab 5.
Yeah.
And if I could take some background to the issue on interregional MIFs at paragraph 54 on page 163.
Paragraph
54.
54.
Thank you. Very briefly, by way of background, the first sentence in paragraph 54, these MIFs, the interregional MIFs, I'm not going to discuss the others, were not the subject of any of the prior decisions, which is obviously relevant to my point about needing to make fresh findings of fact. 4 lines down, there's a reference to the fact that both Visa and Mastercard have pleaded defences, the allegation that those MIFs had an appreciable effect on competition. So it's the appreciability of the restriction is pleaded. And for the purpose of the summary judgment application, both Visa and Mastercard filed expert economist reports, Mr. Holt's evidence for Visa, Dr. Niels' report for Mastercard. And 55, first sentence, the Tribunal notes that the claimants didn't file any expert evidence in response on those questions of fact. Going then to the analysis of the Tribunal, it begins on page 166. And the Tribunal notes in paragraph 62, first sentence only, it wasn't disputed that the interregional MIFs have at all material times been significantly higher than the domestic and EEA MIFs. The 63, skipping down to 63, this is a very important point, the interregional transactions, finding a fact of course by the Tribunal, constitute only a relatively minor part of merchant transactions compared to domestic and intra-EA transactions. The Visa Mastercard submission was that the interregional MIFs do not in fact constitute a floor for the MSC. Mr. Holt for Visa noted that the average MIF for interregional transactions was significantly above the typical MSC for debit and credit cards in the UK. And if I may read out what he said in paragraph 36 of his report, it'll save me going to it. The possibility that MIFs exceeded average MSCs is in stark contrast with the findings from the Commission's analysis in the Mastercard case, that the relationship is the other way around in the majority of cases. Provided that this relationship is relevant to the applicability of the Supreme Court's second fact, a more detailed analysis may therefore be required. In particular, the Tribunal may need to compare the relative level of interregional MIFs and MSCs and the impact of one on the other to determine, this is the critical question the Chancellor asked about intrusion on the negotiation, to determine whether interregional MIFs truly limit the ability of merchants to exert downward pressure on MSCs by reducing the possibility of prices dropping below a certain threshold. And Dr. Niels made a similar point for Mastercard, paragraph 64. Yeah. The small volumes of interregional transactions call into question whether those MIFs would constitute a price floor. It's likely many transactions, particularly in sectors with few interregional transactions, and in the absence of MIF++ contracts. That's a contract that provides for the MIF plus the scheme fee plus the acquirer's margin. Between the acquirer and a given claimant, acquirers will not set separate MSCs for interregional transactions. The MSCs would be set with reference primarily to domestic MIFs and the acquirer's own costs and margins. In such a circumstance, there would be no price floor effect from the interregional MIFs. And even to the extent, says Dr. Niels, the acquirers had some regard for interregional MIFs in determining their MSCs in the absence of the MIF++ contracts. The interregional MIFs are unlikely to represent a price floor in the same sense as domestic MIFs. Domestic MIFs create a level below which MSCs, both overall and those for domestic transactions, do not fall. By contrast, MSCs for any given acquirer are likely to be lower on average than interregional MIFs in respect to transactions overall. As a result, the claimants who do not have a MIF++ contractual agreement with their acquirer, for them, the MSC paid for interregional transactions may also be lower than the interregional MIFs, although this would mean the acquirers incurred a small loss on each interregional transaction. Interregional transactions may be a peripheral consideration when evaluating customer level profitability. And that last sentence, my lords, is a reference to when the acquirer negotiates with the merchant in relation to the MSC.
Is that because the acquirers will usually be negotiating with the merchants for a merchant service charge that's really referable to the domestic MIF?
Yes.
And don't really pay any attention to the interregional ones. And so the consequence of that is that that's the reason why the interregional MIFs may be more than the MSC.
Yes. So there, exactly, my lord. There are really three basic points that come out of this. The first is the tribunal found, as I'll show you as a matter of fact, that the interregional MIFs affect only a minority of transactions with any merchant.
Yeah.
But for some merchants, there really will be no interregional MIF transactions at all.
No.
And the acquirer will know that. It's common ground that different sectors and different merchants negotiate the MSCs differently. The acquirers negotiate different MSCs depending on the characteristics of the merchant. And if the acquirer knows that a particular merchant, and there are, for example, garden centres among the claimants in rural England, they are unlikely to attract interregional MIF transactions. The acquirer knows that in respect of those merchants, they will not be paying interregional MIFs to the issuer.
Expensive shops on Bond Street might be.
They may be in a different category, indeed, question of fact. But for the rural garden centres, the acquirer in negotiating the MSC will not worry about paying out interregional MIFs to the issuer. And that's why it may have no appreciable impact on the negotiation, no appreciable intrusion into the negotiation in relation to the MSC between the acquirer and the merchant.
Do we have evidence as to how the MSCs are fixed? Do you fix a different MSC for domestic transactions and interregional transactions, or do you fix a single MSC for every transaction?
We only have very high level evidence, my lord, in the expert reports, and there was a certain degree of common ground before the tribunal, because of course it's a question for trial. The claimant's position was that it's all irrelevant for the reasons that my friend gave you. We put this fairly high level evidence in, and the findings of fact were made on the basis of it by the tribunal. I'll come to those.
But when you say findings, I don't think a court hearing a summary judgment application finds anything. I think it proceeds on the basis of the facts which are in issue or not for summary judgment purposes.
Indeed, my lord. When I say findings, I mean that's what I mean. I shouldn't use the word finding. That's precisely what I mean. It's only for the purpose of summary judgment that the argument and the plea and the evidence that was put forward reached the summary judgment standard. But on this issue, though, if the court is troubled by why there isn't more evidence from the schemes in relation to the negotiation of the MSCs between acquirers and merchants, the reason is the disclosure is in the claimant's hands. We are not privy to the MSC negotiations between acquirers and claimants. Claimants are best placed to tell us how the interregional MIF intrudes in the negotiation about the MSC with acquirers. Which is why
the defendants are the schemes themselves, the scheme operators themselves. They're not the issuers.
No, indeed not. No.
Yes.
And I'll show you the kind of evidence we would be looking for the disclosure from the claimants if this issue were to proceed to trial as the tribunal directed that it should. So I was at Dr. Neal's paragraph 64, and I go on to 65 if I may, on that same page 167 of the tribunal's judgment. Now, friend Ms. Smith acknowledged that the MSC charged to a merchant will often be a blended MSC that takes account of the fact that a minority of the card transactions will be subject to an interregional MIF. The MSC may therefore be lower than the interregional MIF considered in isolation. But she contended over the page that this in itself does not matter. The key point in her submission is that the MSC was nonetheless higher than it would be if the interregional MIF was at zero. And she relied for that submission on the very same passages in the General Court judgment of Mastercard and the judgment of the Court of Justice of Mastercard that I took the court to before lunch. My short point there is those do not support her point that, as a matter of fact, the MSC for all these claimants will be higher than it would be if the interregional MIF was at zero. That depends on the extent to which the interregional MIF made an appreciable difference to the negotiation between the acquirer and the particular merchant in respect to the MSC. At 67, the tribunal says, in the first place, it seems clear that the position regarding the interregional MIF doesn't fall within finding 2 in the Supreme Court judgment of 93, which is mirrored in the reference at paragraph 103 to the MIF setting a minimum or reservation price for the MSC. Since those findings are set out as summarising the essential factual basis of Mastercard and the Court of Justice that bind the English courts, we doubt we are bound by aspects of the European judgments that go further. But even if we are, the General Court's reference at paragraph 163 to this analysis is to the factual analysis set out in the Commission decision, which the General Court summarised in the previous paragraphs, and I took my words to that. The Court of Justice at paragraph 193 emphasised that the effect on the MSC is not merely assumed as a matter of theory, but based on examination of the facts.
The European Court decisions were not concerned with the inter-regional MIFs at all.
No, indeed not. Indeed not. But my friend relies on them.
It was all domestic and inter EEA.
Indeed, in the European courts it was intra-EEA MIFs, and before the English courts it was domestic. But the essential facts were exactly the same. Then 68, and this is the again important points made here by the tribunal in relation to the factual issues before it for the purpose of summary judgment. On the material before it, the tribunal said, given that interregional MIFs affect only a minority of transactions with any merchant, and differing proportions as between different merchants in different sectors of commerce, points I made a moment ago to the court, the question of the extent to which those MIFs affect the MSCs, which acquirers agree with those merchants, is not, in our view, self-evident. As Mr. Cook from Mastercard emphasised, the effect on competition must be appreciable. The position is manifestly different from domestic and EEA MIFs, which apply to the large majority of transactions and can therefore fairly be regarded as appreciably affecting the MSC, even if it's below those MIFs. And the tribunal relied on paragraph 174 of the Court of Appeal in Sainsbury's that I took you to before lunch. That was where the Court of Appeal said that a very small default MIF wouldn't automatically be a restriction. At 69, the tribunal says, we think the same reasoning applies to a MIF which is not small in itself, but which affects only a small proportion of the MSC. And it went on to rely on paragraph 187 of the Court of Appeal's judgment. We don't discount the possibility that some evidence might conceivably enable other schemes to distinguish different MIFs from those upon which the Court of Justice is adjudicating. In the present case, the MIFs are materially indistinguishable from the MIFs that were the subject of the Court of Justice's decision. In both cases, the MIFs represented the vast majority of the merchant's service charge. And that is a critical factual difference, we say, between those MIFs and the interregional MIFs. But at 70, just to my Lord Justice Nugee's point, this is by no means conclusive. The tribunal said, we emphasise we're not saying that the interregional MIFs do not restrict competition. And we don't understand Mr. Holt or Dr. Neal to arrive at that conclusion. Their view over the page is that this requires further information and analysis. And they recognise that the Commission, in a commitment decision, a non-binding commitment decision, observed that the interregional MIFs determine this is a provisional view of the Commission, determined a significant component of the MSC. But the tribunal says correctly, in my respectful submission, that's only a preliminary conclusion which is not binding on the tribunal and not a sufficient basis, says the tribunal, to find against us in the summary judgment standard. Now, in our respectful submission, that analysis, in view of the EU and domestic appellate authorities, cannot be faulted. We turn then to the claimants' arguments as to why the tribunal was wrong. And for those, we need to go to their skeleton, the claimant's skeleton argument, also in the core bundle behind tab 3. It's page 133, where the claimants deal with interregional MIFs. And we could begin, please, at paragraph 65. The claimants argue that the interregional MIFs represent a fixed artificial common cost imposed upon merchants, and this is the important part, just like the MIFs which were expressly considered by the Court of Appeal and the Supreme Court. And they say, indeed, the interregional MIFs have been significantly higher than the domestic and EEA MIFs, as the Tribunal recognised. The first short point to make on that is, of course, it's a question of fact, whether the interregional MIFs are just like the MIFs which were adjudicated upon by the European courts and by the English appellate courts. And you have my submissions on that. Secondly, the fact that the interregional MIFs have been higher than the domestic and EEA MIFs does not mean that they are, per se, some form of restriction or fall within the facts, the essential facts of the Supreme Court of paragraph 93. It depends on the impact, the appreciability of the impact that they have on the MSC negotiation. And then 66, there's not a dispute before the Tribunal that separate MSCs can be set for interregional transactions, where the MSC for any transaction is the sum of the MIF, scheme fee and fixed acquirer margin, the MIF plus agreement. In that scenario, there's no basis for factually distinguishing the Supreme Court judgment by reference to fact 2, as the Tribunal, they say, purported to do. It's beyond dispute that the interregional MIF in a MIF plus agreement does set a minimum price floor for the relevant MSC, and nothing that we've adduced or anything in the judgment suggests otherwise. Now, for that MIF plus point, I need to go briefly to the same evidence that the Tribunal looked at Dr. Neal's, and that's in the supplemental bundle, tab 15. And these go to page 294, it's paragraph 3.9. But before we read paragraph 3.9, the short point here is true, as a matter of theory, a MIF plus arrangement does create a floor below which the MSC will not go, because it's calculated by reference to the MIF. But whether that is the basis for a finding against the defendants in respect to particular claimants will depend on the evidence of which acquirers and merchants had MIF plus arrangements. And at 3.9, Dr. Neal sets out the information that he would need in this regard and in general. 3.9, he says, further information will be needed to ascertain whether the price floor applies to the interregional transactions relevant to the claimants in this case. This would require disclosure from each claimant regarding whether they had, in fact, any material number of interregional transactions, the contractual arrangements with their acquirer, what kind of agreement, was it MIF plus or blended, the overall MSCs paid by the claimants in respect of interregional transactions, and the composition of issuer countries making up those interregional transactions and the associated card scheme. And then factual evidence from the acquirers concerning how they set their MSCs and the relative level of regard given different types of MIF, the extent to which the interregional MIF intruded into the negotiation. 3.11 though, just before I leave Dr. Neal's, he says, if following such factual investigations, interregional MIFs were considered to represent a form of price floor, so if even in a MIF plus situation, it wouldn't follow that this was a floor with the same competitive effects as identified by the UK Supreme Court. In particular, central competitive effects of the MIF is the notion that the price floor is known and visible to other acquirers in the market. And my Lord saw that in the Court of Appeal and Supreme Court judgments, that the MIF is a known common cost, which acquirers know they can pass on in full and do so. And that was elaborated in the Commission decision cited by the Supreme Court. It's not just that the MIF creates an artificial common cost. It sets a
To the
floor.
extent that acquirers are not are dealing with merchants who where it's unlikely that there will be any customers using cards from outside the UK, then they will have fixed their MIFs on the basis of the domestic regime as opposed to anything else, won't they?
Exactly. They
So,
would,
so actually there's nothing transparent so far as interregional transactions are concerned, because the merchant won't actually, well, neither the acquirer nor the merchant will know what, if any, impact that's going to have.
indeed, my lord. And that's for the.
You were absolutely right, and I just happened to be glancing through the notice of appeal, and there are claimants in there who run garden centres in Devon and car firms in various parts of the country, and it's unlikely that any of those people, any of those merchants, see many foreign clients. I mean, they may see some, but they'd be pretty few and far between, I would have thought.
Indeed. That's the question of fact to explore at trial. That's the argument we'll be making, hopefully by reference to their disclosure. But even for the merchants, the fancy shops on Bond Street that might on the face of it, attract more interregional MIF transactions, even for those, there will be transparency as to the level of the interregional MIF they're paying, but it will depend on the mix of issuers, which will be China, India, Japan, and there'll be different MIFs all over the world in different proportions. And even in those scenarios, smaller proportion from the domestic MIF transactions. And so even there, it will lack the clear transparency that the common cost had in the case of the EEA MIFs and the domestic MIFs. And that's what Dr. Niels, in fact, that's what the Commission, the European Commission said, the pernicious nature of that transparency was what the Commission was citing, was referenced by the Supreme Court in that passage from Dr. Niels. The acquirers know precisely that all their competitors pay the very same fee, and the price floor, the transparency of it, eliminates that element of uncertainty, which intrudes into the negotiation between the acquirer and the merchant regarding the MSC. And 3.12, that factual finding of transparency may not apply in the case of interregional MIFs, the interregional transactions. The importance of interregional MIFs in determining acquirer MSCs for any particular acquirer or merchant would be sensitive to the proportion of interregional transactions that merchant or acquirer accepts, which will not generally be known to rivals. And even when you can estimate it, Dr. Neal says, I understand the interregional transactions, which may also attract different levels of MIF depending on the issuer country, as the mix of issuer countries will differ for the set of transactions processed between acquirers and merchants, so too will the average level of their interregional MIFs. And this adds another element of uncertainty and a lack of transparency in respect to the interregional MIFs that was not present in the case of the UK MIF. So I could go back, please, to the claimant skeleton to finish off their submissions on the judgment. The claimant skeleton back in the court appeal bundle. And now to go to paragraph 68, which really is the claimant's main point. They say, it's page 133, paragraph 68. Where a blended MSC is charged, the tribunal erred in considering that it was legally relevant to consider a factual inquiry into whether MSCs for a given acquirer are lower on average than interregional MIFs in respect to transactions overall, when considering whether interregional MIFs form a minimum price floor in the sense used by the Supreme Court. And we give their reasons for that argument over the page. First, as the tribunal recognised, interregional MIFs affect differing proportions of transactions, as between different merchants and different sectors of commerce. Well, we rely on that. B, they say the fact that a blended MSC for a given acquirer may, depending on the merchant and the sector, be lower on average than the particular interregional MIF. That merely reflects, say the claimants, the high level of the interregional MIF and the greater volume of transactions subject to lower MIFs for that merchant. But of course, it's more than that. Just a point I want to make, the interregional MIF may, as we've been discussing, have for a particular merchant or a particular sector, have no impact at all, no appreciable impact on the MSC negotiation. And that's a different point from whether the MIF is higher than the MSC or lower. But the claimants ignore that and go straight into the conclusion. The evidence adduced by the card schemes did not suggest that interregional MIFs were irrelevant to the setting of MSCs. In particular, none of the evidence adduced by the card scheme suggested that the weighted average blended MIF, including the interregional MIFs, did not affect the weighted average blended MSC, which is the relevant comparison. That's unsurprising, given its common ground in the pleadings. VISA admits there's a relationship between the level of the MIFs and the level of the MSCs. Mastercard admits the acquirers will take account of its costs in negotiating its fee. But we have, as I've said, we have pleaded a denial that the restriction was appreciable.
Well, that's the whole point.
Indeed, that's the question.
Because if that is an issue, then none of this can be decided other than at a trial.
Indeed. And my lord,
Appreciable is presumably an EU law concept.
yes,
Is there any guidance? Is it similar to de minimis?
it is. It's very similar. And there's a particular, there's a guidance from the European Commission on the meaning of de minimis. There's authority from the European courts on the de minimis and appreciability concept. It's cited in the Mastercard decision itself. There's no dispute between the parties of de minimis, which is why I haven't taken to it. But my lord, two sides of the same coin, de minimis and appreciability. The point here is that it wasn't for our experts to say on a summary judgment application conclusively that the interregional MIFs had no appreciable impact on the MSCs. They're not in a position to know. All they could say was this is a question of fact. There are indications pointing one way and it requires exploration at trial. For the reasons I gave, the disclosure lies largely with the claims. Then 69, on the facts which are common ground, the interregional MIF will therefore set a floor for the MSC within the meaning of the Supreme Court judgment. Without interregional MIFs, the prices acquirers charge to merchants will not take into account that artificial collusively grouped MIF and will be taken into account only the acquirer's individual marginal cost and its markup. But as my Lord the Chancellor suggested a moment ago, that's the very question of fact, which requires to be tried at trial.
When you say a question of fact, I mean, you've admitted that the MIFs are taken into account, haven't you, in your pleadings?
Yes, in principle, when the acquirer is negotiating the MSC, it will, in principle, take into account all the MIFs. And in principle, in general, that we admit there must be a relationship in that sense. But whether it's appreciable will depend on the particular facts of the case. And one can see right away why there may not be appreciability. The garden centre in Tamworth or wherever it happens to be, there the acquirer is unlikely to take it into account because it won't be relevant, because the acquirer won't be exposed to that payment to the issuer, and therefore it won't feed into the MSC negotiated between it and the merchant. So stepping back then, and concluding on this point, the appellate decisions that I took my lords to make very clear that the factual inquiry as to the impact of the MIF on the level of the MSC is central to the analysis. That's of utmost legal relevance. It's not legally irrelevant to the claimants submit. And the factual situation of interregional MIFs has never before been considered by a court. It's only where the facts of a case are materially indistinguishable from those considered by the European courts in the Mastercard cases are those decisions binding. In other words, the factual circumstances, to the extent we can identify them, of the interregional MIFs do not show that those MIFs are materially the same as the ones considered by the Court of Appeal and the Supreme Court. And the unchallenged evidence of Dr. Niels and Mr. Holt show that they very well may be distinguishable. The general admissions that I have discussed with my Lord Justice Newey isn't enough to establish summary judgment on this question. The final point that the claimants make at paragraph 70 is that even if the claimants could establish a trial, that there were instances where MSCs are lower than a particular MIF, that would not mean there's not been a distortion of competition for reasons given by the General Court. And of course, we accept that. But that begs the question, what will be established at trial? It's not just about whether the MIFs are higher than MSCs. It's the question, the risk of repeating myself, as to whether, in particular negotiations of particular MSCs, this MIF had an appreciable impact on that negotiation. So that, my lords, is the end of my first point. I said I had three. The other two I can deal with more briefly. The second of my 3 points is the point we make in our respondents' notice, the different competitive conditions for inter-regional consumer MIFs. May I take you to our respondents' notices to show you where we raise it? That's in the core bundle again, behind tab 10. Respondents' notice, page 207. And in other words, I'm looking at the very last, it's the last 2 lines of the text on page 207. So in addition, or alternatively to the points to the conclusion of the tribunal, we say summary judgment should nonetheless be refused owing to the different competitive conditions in the acquiring market for inter-regional consumer MIFs as compared to the acquiring markets that were considered by the European and domestic appellate courts. So the tribunal is, as I've seen, stopped at the first of those. We raised 2 other reasons why inter-regional MIFs may be distinguished, and I'll ask this court to examine those. And we see that first in Mr. Holt's first report. It's in the supplemental appeal. So further likely factual distinctions. Behind tab 16. And paragraph 44, please, on page 315. So here, Mr. Holt is opining on the competitive dynamics in the inter-regional, inter-system market segment. The competitors that Visa and Mastercard face in this market segment are very different from those which it faces in relation to EEA MIFs and the kinds of transactions which attract domestic MIFs. The set of competitors faced by the schemes in the interregional market differs markedly from the ones that we've seen in the judgments. There are multiple international 3- and 4-party networks, as well as digital payment solution providers that are active or not as active in the UK issuing market, which compete with Visa and Mastercard for these type of transactions. And interregional card, CP is card present, CNP is card not present. And pausing there, in other words, against common ground that for interregional MIF transactions, there are far more card not present transactions. One finds a lot more online commerce where interregional MIFs apply. China Union Pay is obviously a massive player in this market, the largest card payment scheme in the world by value, and it has a foothold in the UK by expanding its acceptance network through partnerships with Barclaycard, accepted by a large proportion of UK merchants. And of course, the merchants that we'll be targeting will be the ones most likely to attract China Union Pay customers. So the kinds of transactions which might attract, more likely to attract inter-regional MIF payments. B, Japan Credit Bureau. I'm not going to read out all of this text, but one sees the kinds of schemes operating in this sector. American Express, obviously, and over the page, PayPal, Alipay from China, and WeChat Pay, another major third-party payment solution in China. 45. The presence of these competitors suggests that a reduction of Visa's and Mastercard's inter-regional MIFs to 0 could have led to very different outcomes when compared to a reduction in UK domestic MIFs. And the point there is that if the issuers are getting 0, and they're less likely to encourage card usage, the card holders are more likely to switch to these forms of payment mechanism. These other forms of payment mechanism, Amex is a good example, are more expensive for merchants, and may well be more expensive for merchants than the Visa and Mastercard MSCs. And therefore, the merchants may pay more if there's a big switch to these kinds of mechanisms.
That's why a lot of merchants don't take Amex.
Indeed, precisely. And that goes to the 6th fact in the Supreme Court that the MSCs would be lower in the counterfactual. It was part of the Supreme Court's list of essential facts, which would be different, we say, could be different, if, on the claimant's case, the interregional MIFs were forced down to 0.
Yeah, can I just think about that for a moment? I mean, the Supreme Court was talking about the MSCs being lower in the particular scheme. Was it not? It wasn't saying, it wasn't drawing comparisons with other schemes. It was saying in this particular scheme, the charges would be lower.
My Lord, with respect, no. That is a question of, this is a disputed issue between us. We read that passage in the Supreme Court's judgment to mean the MSC generally. Logically, if the concern is merchants suffering as a group, it must be MSCs generally in the market, because if it's just the Visa, if it's just the MSCs in relation to Visa and Mastercard, then merchants will not suffer overall. They would switch to other acquirers, other systems for lower MSCs. For it to make sense, it has to be MSCs across the board, and we see that in Mr. Holt's evidence. And maybe, since you're in it, to go please to Holt 3. Paragraph 22, page 328. Page 328, paragraph 22. So we say, well, it must be MSCs generally, but I don't understand that to be common ground. Because the concern that the Supreme Court had was that merchants would be worse off overall. They would face MSCs in general that would leave them worse off. And so that's not a 1013 point. That's the vice that was created by the MIFs. If it's just Visa and Mastercard MSCs, then it's hard to see where the harm arises.
I'm puzzled actually now, because who else is charging MIFs?
No, it's MSCs, my lord. No one else is charging MIFs.
Taking out the MIFs from the MSC, the point the Supreme Court's making is if you take out the MIFs,
Yes.
you reduce the MIFs to 0, then the MSCs would be lower. But that surely is a fact that only applies where there have been MIFs in the first place, which have been reduced.
Well, MSCs here, I understand, if I'm wrong, I'll be corrected, extends beyond the MSCs arising from MIFs. The MSC is the charge that's charged to merchants when any other form of payment mechanism is used, such as Amex.
If you take Amex as the example, surely there wasn't any evidence, was there, as to what the position would have been with third-party schemes like Amex and Diners. I don't know if Diners is still in existence, but Amex. I can't remember there being anything in the Court of Appeal, at least, which bore on that issue at all.
I hesitate. Of course, my memory is also not perfect on that issue. There was definitely a discussion at first instance about the fact that the merchants paid more where Amex card was used, but I'm not going to give evidence as to what was or was not.
Sorry, they are only supposed to do this between 12 and 2, and 4 and 6. I don't know why they've suddenly started doing it at 2:45.
Well, perhaps that might be a convenient moment for me to move away from this point about MSCs, because I can't really help you more than show you paragraph 22.
Just so I understand what the case is, we're dealing with Supreme Court Little 6, are we?
Yes.
And Little 6 says, in the counterfactual, the whole of the MSC would be determined by competition and the MSC would be lower. And the counterfactual, on the face of it, is something tied to Mastercard and Visa. report of Mastercard and Visa.
That's why I was puzzled by your submission, because it's just not touching on the other schemes at all. There's no evidence about them.
No, indeed, and of course, the Supreme Court wasn't addressing other schemes, but when they say, and the MSC would be lower, the reason why I submit, and must be Mr. Holt's evidence, that it has to be the MSCs that the merchants face generally, is that otherwise, presumably the merchants would shift away from the higher MSC to one that was offered them by somebody else. But I'll come back to that, because it may be there's something else in the documents that can assist. But the main point is, Moritz, that even if I'm wrong about that, and even Mr. Holt's wrong, and it's just the MSC, it doesn't affect the next point which we make about competitive conditions. But that's it. The first point depends on the MSCs generally. I'll come on there to the next point about competitive conditions, and that is third factual distinction, paragraph 31 in Mr. Holt.
Right.
He says, and this is the fraud cost point, based on his work as part of the European Commission's investigation into inter-regional MIFs, he's aware that issuer fraud costs for inter-regional transactions are significantly higher than those for domestic and intra-regional transactions. It makes it more likely that a reduction in Visa and Mastercard's inter-regional MIFs to zero would divert transactions to alternative payment methods better placed to reflect the costs in their pricing. So, and this is the point that Nugee made, that the issuers pay fraud costs. Fraud costs are higher for inter-regional transactions, and that's a cost that the foreign issuers bear. If the MIF for these, if the inter-regional MIF was zero, these foreign issuers would be less likely to encourage their cardholders to use Visa. They'd be less likely to badge their cards with Visa in the first place, and they would encourage their customers, or their customers would anyway, switch to other payment schemes, which would increase, and again I come back to the same point, 32, increase the MSCs paid by merchants, and that is the same point, actually, that the merchants end up paying more than they would facing Mastercard or Visa. Sorry, I've been told this evidence is not in the bundles, unfortunately. Sorry, I've just been told, Mr. Pitchner, that we wrote to the tribunal before the hearing, which is in a letter that I don't understand is before you, that these MSCs, the Visa and Mastercard MSCs, apply across schemes. Across schemes, including not just Visa. That's the point. The acquirers apply an MSC to merchants that includes not just Mastercard and Visa, but also other card schemes. They can pay a merchant will often pay a single MSC in respect of other schemes that is joined with the Visa Mastercard MSC. I think that's the Visa or Mastercard MIF is mixed up with a big MSC that the merchant pays. That's the point. Now there was definitely evidence about that. But I don't.
That includes what Amex and Diners Club, if that still exists, does it, or what?
I don't know about Diners Club, but Amex certainly. But and it doesn't
There's
apply.
nothing else in this jurisdiction, is there?
I don't think so. I don't know.
No, I mean, intra-EA MIFs are more complicated. I'm not sure whether the carte bancaire system ever, whether it's still in existence or whatever. But
I remember now. This was the merchant would face a single MSC that would not be blended, but have blocks of different payment scheme charge within it. So the merchant would pay a single bill. I think that's what we put before the tribunal. Unfortunately, not before you.
no,
I'm sure we can dig out that.
later, time.
But that, and of course, that's that's necessary for the 2 points I've just made to you. I'll move on if I may, because that really is the end of my submission on that second point, the different competitive conditions. And I'll move on to my third issue, VISA's Respondents Notice Ground 2. For this, back to the core bundle, please, and tab 10. Page 207. And at the top of the page under Bilateral 2, this again is our appeal against the finding that we had no arguable defence relying on the fact that interregional MIFs were set all the time by VISA Inc. alone. And I'll rely on, in part, what Mr. Brewer said in opening on that point. But it is of particular significance for the interregional MIFs, because they were set by VISA Inc. throughout the claim period. This last point I'm making to you, if I'm right, means that the interregional MIFs could not involve a restriction of competition, or certainly at the summary judgment standard, could not be found to create a restriction of competition. Even if I'm wrong about everything else that I've said about interregional MIFs, this would be a complete answer on the summary judgment.
This is just a gloss on what Mr. Rubinovic told us this morning. Isn't it?
Yes, it's an extra point on
It's
top
an
of
example of a scenario in which, in this instance, all the MIFs were set by VISA Inc.
Yes. But
So if he was right in what he told us this morning,
if he was right, then
this will follow.
this will follow. But there's a further point about this, because we made this point to the tribunal. We obviously made the point that Mr. Binovitz made to you. That was the first of 2 points that we made.
Yep.
The second point arises from the relationship between VISA Europe and the overseas issuers. Because before the tribunal, we argued that overseas issuers have a contractual relationship with VISA Inc., not with the defendants in these proceedings. And VISA Inc. isn't a defendant to this claim. VISA Inc. was a defendant to one of the claims before Ms. Justice Phillips. But for whatever reason, these claimants haven't sued VISA Inc. And that's relevant to the counterfactual. We have to go back to basics in the counterfactual. Because the claimants claim that VISA Europe is responsible for the anti-competitive effects of the interregional MIFs. That's their pleaded case. But for that being to prove, as a matter of fact, what VISA Europe would have done in the counterfactual, and to demonstrate that this would have been better for competition than what VISA Europe did in the real world. And that counterfactual...
You say VISA Europe wouldn't have in fact been doing anything because the MIFs were all set by VISA Inc.
VISA Europe was powerless in this regard. And of course that's relevant because, as my Lord the Chancellor held in the Court of Appeal in Sainsbury's, the counterfactual has to be realistic and likely in the actual context. And that's the very point here. And in relation to the domestic MIFs, sure, the realistic and likely counterfactual was described by this court and by the Supreme Court, that there would be no default MIF with settlement to par, the same as a zero MIF with settlement to par. It was realistic and likely because the courts had found that these defendants would have done that pre-IFR on the facts in Sainsbury's case. If they couldn't have the positive MIF, the courts found these defendants would have changed the MIF to zero. They had the power to do that. But what is the counterfactual in this case in relation to the interregional MIFs? Is it realistic and likely that these defendants could ensure a zero interregional MIF with settlement to par? And we say, no, not at all. These defendants have no control, as I said, over the interregional MIF. VISA Europe cannot stipulate that these overseas issuers in China or Japan must settle at par with no deduction for settlement fees. Only VISA Inc. can do that. And that's why we say the fourth fact of the Supreme Court's 6 facts cannot be met in relation to this aspect of the claim. So we see how the tribunal dealt with that. If we go back to the judgment in the core bundle, down tab 5.
Yeah.
And it's, I'll begin, if I may, on page 155. Because in my submission, my respectful submission, there's a fundamental internal contradiction in the judgment on this issue. Page 155, we see a paragraph 38, the tribunal quoting from the Supreme Court's judgment in relation to the counterfactual. Go over to page 39, having cited the 6 facts of the Supreme Court. Sorry, in those 6 facts, the Supreme Court said in fact 5, the counterfactual there would ultimately be no bilaterally agreed interchange fees, no bilateral counterfactual. 39, the tribunal said the reason why the counterfactual is not a situation with a series of bilaterally agreed interchange fees when it involves a prohibition on ex post pricing or a no default made for settlement of par is to preclude what is referred to as the hold-up problem. And the court has been through that in detail with my friends. But the tribunal, obviously bound by the Supreme Court, and for its own reasons here held that there would be no bilateral counterfactual. But then at paragraph 105, page 180, skip ahead please to page 180, we have the tribunal's analysis of the VISA interregional MIFs.
Yeah.
They summarise my submission 105, very like the one I just made to my lords, that the interregional MIFs that apply to transactions with merchants in Europe. Sorry, over the page, I submitted that VISA Europe couldn't deliver the counterfactual since it can't require the relevant issuers for the purpose of the interregional MIF to accept settlement at par. 106, the tribunal said, we accept that the level of the interregional MIFs is set by VISA Inc. without the involvement of any of the VISA defendants. But they said it's common ground that the agreement to abide by that level of MIF arises under the scheme rules. The acquirers in Europe, their obligation to abide by the rules is a contractual obligation which they enter into with VISA Europe. They say it's pursuant to those arrangements that the European acquirers have to pay the interregional MIF. 107, it's true that VISA Europe isn't responsible for requiring overseas issuers to charge the interregional MIF, nor does it set the MIF. But they say the tribunal doesn't alter the analysis because under the VISA Europe rules, you have to pay the interregional MIF. But again, to show that that is a restriction of competition by effect, one has to ask, what is the counterfactual? And recognising in my submission that VISA Europe can't actually compel the issuers to settle at par, the tribunal went on to suggest in my article submission a different counterfactual, a completely new one from the ones that this court and the others have examined. Look at the very bottom of 181, page 181. No European acquirer will effectively negotiate independently for a lower interchange fee than overseas issuer, since the issuer knows in a default of agreement the acquirer is obliged to accept the interregional MIF. That's not the zero MIF counterfactual, but that's a suggestion that in the absence of the interregional MIF, in the absence of an agreement pursuant to which the European acquirers agree to pay the interregional MIF, European acquirers could negotiate with, say, a Japanese or an American issuer bilaterally to settle on the basis of a lower interchange fee. And that has to be, in other words, a bilateral counterfactual. But that's the very counterfactual that was rejected by the Supreme Court and indeed by the same tribunal in this judgment. And it was never pleaded by the parties. There's nothing to support it and no reasons here to suggest where it came from. It's impossible to see how this good ground summary judgment.
This sentence at the end of 107 is not dealing with the counterfactual, it's dealing with the real world. It's making the point that at least so far as the position in Europe is concerned, that the effect of the interchange fee, even if it's set by Visa Inc., is that the acquirers' hands are tied in the same way as they are if the MIF had been been set by VISA Europe. So it's simply dealing with your case that Visa Inc., because the MIFs were set by Visa Inc., and because of the contractual relationship of the issuers with Visa Inc., that there was no, well, in effect, they'd sue the wrong party, I suppose is what it comes to.
That's what it comes to. I mean,
No, I mean, this sentence is you may be right about that, but this isn't dealing with counterfactuals.
well, the reason, and it's hard to work out really what is going on here because it came out of nowhere. But the reason why I submit that it's a counterfactual point is that it's true that they're describing what happens, the vice, but it has to be that if we're wrong, if the claimants are right on this point, the tribunal must be finding that a European acquirer could, in the counterfactual, effectively negotiate independently for a lower interchange fee with an overseas issuer. But that's a finding that in the absence of the restriction, that's what would happen, and that would have to be a bilateral outcome. And that's why I say the counterfactual here is bilateral. And that's the very thing this tribunal rejected. That's why I make the point, because it has to work that way. But in any event, as you say, as my lord says, it's really a question of suing the wrong person. It may sound like a small thing, but it has big implications for the inter-regions.
Insofar as the regions which are inter-regions are outside Europe, then your point's a good point anyway, isn't it?
In my submission, yes. I'll just quickly check if anything else to say.
I'd say on that last point, is that that last sentence is equally true in the counterfactual. So it's not them, it's not caused by
I'm asked to say that last point, that the very last line in page 181, is equally, I think the point that we're making is equally true in the counterfactual. Okay. Which is why it doesn't demonstrate any effect, any anti-competitive effect. I've been asked also, before I sit down, to tell the court where the rules are. This is, I think, the point.
Yes.
Several, my lords. The old rules are, and there's no need to turn them up, in the supplemental bundle. It's in the annex to the Court of Appeals judgment in Sainsbury's, in the authorities bundle, tab 12, page 1080. The new rules, are online. They're not in the papers before the court. We can provide those by email overnight if the court wishes to have them.
Yep. Thank you, Mr. Kennedy. Yes, Mr.
Thank you, my lord. My lord, as probably anticipated, a very large proportion of my thunder has been stolen by my learned friends to my
Right.
Yes. My lord, as you probably anticipated, a large proportion of my thunder has been stolen by my learned friends to my right, and I'm going to try not to weary the court
I
by...
thought that might be the case.
Yes. Yes.
You can be relatively short.
That certainly is my hope and expectation, and I'm sure the court's expectation. What I will be addressing, my lords, is the arguments under ground one briefly, particularly insofar as they relate to Mastercard's bilaterals counterfactual. Some additional points on the interregional MIFs not already made by Mr. Kennelly, including in particular the objective necessity argument that is raised in my respondent's notice. Before I start my main submissions, though, there are just a couple of questions that the tribunal the court has previously asked, where there haven't been either clear answers or answers that we agree with. So I'm just going to briefly just sort of tick those off. Yeah. On day one, page 21 of the transcript, Lord Justice Nugee asked what determines when a transaction is a domestic transaction. Just briefly, for the Mastercard scheme, a domestic transaction is one which occurs at a card acceptance location in the same country as the country in which the card was issued. So it's the location of the point of sale in the sense of the sort of the electronic device, and where the card was issued is the important question for domestic transactions under Mastercard scheme, no doubt similar under Visa. On day one, page 29, Lord Justice Newey asked where the risk of fraud lies. It's something in that respect is a very important issue for this case as a whole. It's very easy, given the focus on interchange fees, to overlook the fact that interchange fees are just one element of the default settlement rules. And that's a point we pick up at paragraph 35 of our defence, which is in tab 3 of the supplemental bundle. We don't need to go there for now. It's just I'm not giving evidence from nowhere. It's something we plead. But the default rules also govern, among other things, when the issuer, or whether the issuer, has to pay for a fraudulent transaction, or what are called chargebacks, because quite often the transaction will be paid straight away, and then it will appear on the statement, and at that point, the cardholder says, wait a second, that's not mine, so you charge it back. But that's merely just a cash flow point.
Just so I understand that, I mean, you know, having been more than once the victim of that sort of card fraud, my bank would simply reverse the transactions. So, but as between me and the bank are bearing the risk. But the point you're making is that within the scheme, that risk may be spread between issuers and acquirers. Or
Well, I'll come on to how it's spread. I mean, the Mastercard rules in general, it's true with Visa as well, govern sort of the internal arrangements with the scheme.
Yeah.
For the most part, they don't say, for example, you know, what you should do in terms of your sort of relationship with cardholders.
Right.
So that's governed by either your bilateral relationship with your bank, subject to things like you know, legislation that's in place to try and protect,
Yeah.
or either formal legislation or the way in which regulators put pressure under banks to operate in particular ways or be named and shamed. But in terms of how it works, the default, firstly, that is a default rule, i.e. they're ones that are, again, subject to different bilateral, or the possibility of different bilaterals. But in terms of the factual position, during the claim period, our default rules have generally required issuers to make payments even if they're fraudulent. And the word generally is sort of used there because this isn't a simple rule. There are circumstances in which the fraud guarantee will not apply. So in general, if there's some available form of fraud protection technology, like the various things one has when one now makes an online transaction, and a merchant chooses not to adopt those, in those circumstances sometimes you know, the merchant can be on the hook if they're not taking advantage of available technology. So it's a general position, it's not a universal position. We say that is, of course, a substantial benefit to the merchant. It's also a substantial cost to issuers, and the interchange fee contributes to those costs. Now, of course, contribute here, the interchange fee is simply a fungible fund of money, but nonetheless it is a fund of money which, among other things, is available to contribute to costs like that, which are inherent costs of being part of the scheme. That's the factual position. We do plead as well in our defence that if we hadn't been able to set positive interchange fees, so acquirers and merchants weren't contributing to the cost of fraud, then one possibility is having different default settlement rules, so that kind of fraud guarantee wouldn't be in place, which would simply pass the cost
I
back.
think my recollection is there was some evidence about this
Yes.
in the section 1013 as part of
Yes.
the court appeal. Yeah.
Yes. And these are points that probably do end up ultimately being relevant to the 1013
Yeah, sure.
points.
Sure,
But
understood.
yes, but nonetheless, I mean, the
Yeah.
question was asked, and we simply explain how we see it, which is that the payment guarantee against fraud is one example. The time of payment is another example. These are benefits to merchants, and their benefits, we say, arise in part from the interchange fee. The next question was day one, page 40. My Lord, the Chancellor asked about Amex and diners. I mean, firstly, diners is still out there in the United Kingdom. It's still out there, operates in about 70 countries worldwide. But I think it's probably its market share here in terms of who actually has a card here, but in terms of people coming into the country, it is certainly still something one sees.
Yeah.
But in terms of Amex and diners, are they competing in the same market or a different market, which was my Lord's question. What we say in relation to that is Amex in particular, while the historic position, and by historic I mean going back well over 20 years now, was that Amex was operated as a three-party scheme, Amex being both issuer and acquirer in that model. It's now operated for over 20 years in what we call in the jargon of these cases a 3.5-party scheme. And what that means, at least within the United Kingdom context, and it has different models in other countries in the world, is that Amex continues to operate essentially as sole acquirer, but it licenses other financial institutions, such as major high street banks, to issue Amex cards themselves. So you could, for example, for a long time, have got a Lloyds Bank Amex card issued to you by Lloyds Bank, but it was an Amex card and it was processed through the Amex scheme. And in order to persuade banks to issue Amex cards, Amex has always offered what is essentially, use different terminology, but what is essentially an interchange fee, i.e. a payment from Amex as the acquirer to the issuing bank, which is licensed to issue Amex cards. And that payment flow is of course designed to make Amex competitive with the interchange fee revenue that those banks would get if they issued a Mastercard or a Visa instead. Significantly, there has never been any challenge.
In terms of the economics, it's a different scenario, isn't it?
It depends what you mean by the economics. In terms of the economics of who gets money,
Wrong word.
yes.
But the point I've got in mind is that there you've got Amex as acquirer specifically paying effectively an interchange fee to the issuing bank to encourage the issuing banks to issue Amex cards.
And to that extent, it's identical
To that
what's-
extent, it's different from the Mastercard scheme where the acquirers are not, and as far as we're aware, anyway, from what we've seen, the acquirers aren't paying the issuers pursuant some contractual arrangement between them.
Well, certainly it's not bilaterally negotiated.
No, that's what I mean.
No. I mean, there are certainly, the distinction, and I think, one can question why it's never been challenged, but probably one of the most obvious reasons why it's never been challenged is that there is no scope for competition in the acquiring market for Amex, because Amex is sole acquirer.
Yeah.
So it's that.
That's right.
It's that competition, that there is no competition, so they're not liable for restricting it. But in terms of the economics, the Chancellor's point, the actual economics are the same. The cost to merchants is, in fact, higher in general than under Mastercard or Visa.
Yeah.
The flows to banks are historically equivalent or better than Amex or Visa. And subject to sort of some fairly complex rules about market shares, the 3.5-party schemes, or the 3.5-party element is subject to the interchange fee cap as well. So those flows are subject to the same 30-20 basis point caps. So what the reason why I sort of dealt with those points. So what we do say is, looking for the moment at the UK domestic market, Amex does compete with Mastercard and Visa for the business of issuers, and therefore we say Amex does compete in that inter-system market, which is what the question was about. Once you're outside the UK, there are a variety of other competitors, a variety of domestic schemes in a lot of countries. The Chancellor mentioned Carte Bancaire, which in France is still very much a successful predominant card scheme in there. And then when we look at the interregional market, which by definition, one's looking at countries outside Europe, you've got China Union Pay, Alipay, China, JCB in Japan, etc., and of course, you know, Amex and diners worldwide, but Amex in particular being a very major player in that sort of international, interregional market. And it's important to recognise, and I say this is an important point when we come to look at interregional MIFs, that while we're talking about a MIF that's paid, or rather an MSC which is paid in the UK, or because some of these claims do relate to countries elsewhere in Europe, we're talking about whether Mastercard can viably offer a cross-border payment product to cardholders in non-European markets. So it's in that context, it's competing with, in Japan, JCB, in China, WeChat or Alipay. And then if one turns to the issuing market, so the market for issuers trying to get the business of cardholders, there you are competing with all of those kind of players in the UK market, both what we call Amex proprietary, and Amex proprietary means Amex issuing the cards itself, Amex issuers, Mastercard issuers, Visa issuers, and then also a variety of other non-card-based payment products, PayPal being one of the better known ones, and the increase in a variety of pay later products that one sees online in recent years, pay in 3, pay in 4 kind of delayed payment models. So those are the kind of competitors one sees in the issuing market. So we do say those are all important competitors in those markets, and that's important particularly for interregional, which I'll come to in due course. The next point was that on day 1, page 42, my Lord the Chancellor asked whether it was correct that issuers and acquirers would usually be the same people. And I'm afraid one of the extracts that came in this morning was in answer to that, which is an extract from the Payment System Regulators report that, it's the point I refer to on that. I mean, I don't going to take you to it. It's supplementally bundle tab 19, page 344, spot 1. It's paragraph 350. And that simply confirms that the present position is there are only 2 acquirers left. I mean, historically, there was a lot more overlap. There are now only 2 acquirers left who are still fully or partially owned by UK headquartered banks. The majority of acquirers now are standalone acquiring businesses.
It's quite interesting, isn't it? Sorry?
Tab 19. Tab 19, page 344.1. And what's largely happened, my Lord, and I'm at the stage of sort of giving evidence, I suppose, but is effectively those who have been spun off, the acquiring businesses have been spun off as standalone businesses.
344.1.
344.1, it's paragraph 350, which I'm essentially quoting from. Only 2 are fully or partially owned by UK headquartered banks. And I think if we go back to the previous page, page 3.48, it says in 2018 there were 100 acquirers and over 50 payment facilitators providing car acquiring services. Now, fair to say that a couple of the largest are the couple we're talking about there, but nonetheless, the majority, many of the biggest ones are not in fact acquirer owned anymore. It's not in fact owned by banks who also offer issuing. The same, and it logically follows from that the vast majority of issuers equally just have a standalone issuing business. So at least today, and certainly in recent years, it's the exception rather than the rule that the issuer and acquirer will be the same entity. And the other question I wanted to deal with, which was a question asked today, I think by Lord Justice Nugee, about the honour all card provisions in the Interchange Fee Regulation, and just exactly how those operate, because I think it's fair to say those are fairly confusing, and that's going to be in core bundle. No, sorry, it's going to be in Authorities Bundle 3, tab 16, Regulation 10. My Lord, if we just do this, and I'll have dealt with the questions, and then can make my main submissions after the break. So we just finish this one off. And I suppose the starting point to make, of course, is that, and it's fair to say this is true generally of the IFR, is it prohibits certain things, and then, you know, as a consequence, its rules, in essence, allow. That doesn't, of course, mean that that is lawful as a matter of competition law, which is what we need to fight about. But in terms of how the rules operate in Article 10, which is on page 1211, it starts off with, as I said, it's slightly confusing, it starts off with a prohibition on essentially an honour all cards rule, which is Article 10(1), and then it brings it back in subparagraphs 2 and 3, which is where the confusion arises. So subparagraph 2, effectively the prohibition shall not apply to consumer card-based payment instruments of the same brand and of the same category, subject to interchange fees under this regulation, so subject to the caps. So, for example, if you're talking about Mastercard debit, consumer cards within Europe will all be subject to the interchange fees, and we're allowed to have an honour all cards rule for all European Mastercard consumer debit or all European Mastercard consumer credit, because those will all be subject to the caps. And that's effectively saying that, you know, they're all the same, there's no reason to discriminate. And then subparagraph 3 provides that the prohibition in subparagraph 1 on the honour all cards rule doesn't prevent you having an honour all cards rule that says essentially you can't refuse on the basis of the identity of the issuer.
Well, all paragraph 3 effectively providing that so far as Visa and Mastercard are concerned, they're entitled to have an honour all cards rule which doesn't entitle an acquirer to entitle a merchant rather to refuse to honour particular bank's cards.
Yes.
That's what it comes to.
That's where we end up. But it's very odd because you have the prohibition.
Point about what would happen if there weren't an honour all cards rule, so individual banks could say, well, we're not going to charge a MIF, and somebody else would say, well, we are, and then the merchants and the acquirer could say, well, actually, we're not going to honour those cards, because they're too expensive. What this is saying is that if you're running a part card scheme, then you can prevent that from happening.
Yes. So certainly it's the regulation permits us to do that. I acknowledge that doesn't necessarily mean.
No, I understand, but I mean
that's just lawful as a matter of competition.
Yeah. Okay. Is that a convenient moment to have a 5-minute break?
Crazy. You know, all we needed was dynamite sticks going on. Just take our seats there, ladies and gentlemen.
Thanks for coming.
I mean,
Might. Yeah. Might, no, maybe not. We'll see. Probably not.
only on objective necessity. I can't imagine they're going to have any desire to do anything on that at all.
I don't know who's allowed to reply to, who's reply or which reply or that reply.
Just going to keep my impulses to keep popping up in front of the fire. Let's have one more go. It's been so much fun.
Silence is all rise.
Yes, my lords, the claimants or the appellants ground one will turn to the substance of Mastercard's bilateral counterfactual shortly, but I will just briefly address the relevant legal principles. I mean, these have been largely dealt with by Mr. Rabinowitz, so I don't need to traverse the same material too much. I'm just going to do is summarise my position in a series of propositions. The one authority I will briefly refer to is Mastercard CJEU judgment, which is in authorities now bundle 1B, since I hope those have been split to avoid the ire of the court, and that's at tab 5.
Yeah, thank you.
Do you want us to have that? If you could, my lords, because that will be the one I will come back to a couple of times. So, proposition 1. The relevant question for counterfactual analysis in the context of restriction of competition, as opposed to objective necessity, is what would happen in the absence of what are variously described in the cases as the measures in question or the agreement in dispute. And that's carte bancaire at paragraph 111, Court of Appeal in Sainsbury's, para 127, and it's also Mastercard CJEU at para 161. And that's a point that's also picked up in the judgment, paragraph 36. What I'm saying is each of my propositions is the approach that the tribunal took, and it was right to do so. And So that's 161, which is at page 371 of the CGAU judgment, or 371 of the bundle. And they use the phrase there, the agreement in dispute. And we can see at paragraph 164 at the bottom of the page, what they see as being the agreement in dispute. It says, by contrast, the court should assess the impact of the setting of the MIF on parameters of competition, sets them out, coordinates necessary in accordance with the settled case law referred in paragraph 161 to assess the competition in question within the actual context in which it would occur in the absence of those fees, and those fees being the MIF, the multi-lateral interchange.
Yep.
So we say that's quite clear. What we're talking about is the absence of the multi-lateral interchange fee. Proposition 2. The counterfactual is determined by looking at what is likely to happen in the absence of the measures in question within the actual context in which the relevant agreement operates, including likely developments that would occur. And that last little bit, likely developments that would occur, is why you can include in the counterfactual additional changes to the scheme, such as introducing settlement at par. And we get that from paragraphs 161 and 164, which I've just referred the court to, and then also paragraph 165, and in particular 166. And it's the last sentence of 166, which is the bit, it's permissible where appropriate to take account of the likely developments that would occur on the market in the absence of those arrangements. And the addition of further rules is a likely development, or it may be depending on the facts.
Yeah.
And again, that's picked up in the judgment, in this case at paragraph 49. What I say is it follows from those two propositions that with respect, Ms. Smith is simply wrong to assert that the counterfactual must create a hypothetical world in which competition can occur. In respect, Ms. Smith hasn't identified a single decision which supports that contention. It's directly contrary to the clear law I just showed you of how you should do this. Look at the actual context, taking account of likely developments, and as Mr. Rabinowitz submitted, it's self-serving and circular,
It's
essentially.
the point that I made to Mr. Rabinowitz, isn't it? That if that were right, then you'd never have a situation where when you did the comparison between the real world and the counterfactual world, you reached the conclusion that the measures in question had not, in fact, caused the competitive, the competition issue, or whatever, however you describe it, because it was something else.
Because by definition you've excluded it.
By
which is-
definition,
yes. Absolutely, my lord, and I completely agree with that. You don't start with the asserted vice and then reason back in order a way which guarantees the asserted vice is right or applies by removing it. And that, of course, is what Carte Bancaire confirms, is the counterfactual is to determine whether the competition situation would have been different in the absence of measures of question. That shows the point. It's begging the question, and anything else would be just assuming the answer. So another way of looking at this is if you can lawfully get to the same place by a different route, then it's not unlawful to do it collectively. And that's really what, or rather your collectivity has not added any unlawful element if it gets to the same place as a different route. Now my proposition 3 is in relation to the pre-IFR period. The settlement at par counterfactual was only adopted because there was no other viable alternative to the MIF. And we see that in particular at paragraph 173 from the CGA-EU judgment. It says, it follows from this that the only other option presenting itself at first instance as enabling the Mastercard system to operate without a MIF was in fact the hypothesis of the system operating with ex-post pricing settlement at par. So that was just simply, before the European courts, there was only one alternative on the table. And that's why we say it wasn't, the Court of Justice wasn't endorsing some sort of general application. It was saying nobody suggested an alternative. there's only one way the scheme can survive, then perforce that's the right counterfactual, because there's only one counterfactual on the table.
Because if you don't do that, it will collapse.
It will collapse, yes. Well, and they go further than that. I mean, that would be sort of relevant for the objective necessity, but at the end of this, they say at 173, it will collapse, and nobody's suggested that Mastercard would prefer its scheme to collapse rather than operate it in a slightly more flawed fashion.
So if Mastercard is faced with a choice of either it collapses or we adopt settlement at par, we'll adopt settlement at par, and that's one of those likely developments.
Yes. Yes, absolutely. So that's before the European courts. Sorry, and just on that, that's picked up at the judgment of paragraph 39, that was the basis of the Court of Justice's finding. And in terms of Mr. Rabino, it's called the first round of litigation, the UK proceedings, as recorded in the judgment at paragraph 46, other options were canvassed at first instance, particularly before Mr. Justice Popperwell. And one of the things he also considered in particular was a pure bilaterals counterfactual. And he dismissed that as being a credible or a realistic alternative because of the hold-up problem and the collapse issue.
The CAT had said there would be bilaterals, hadn't it?
Well, and that's what I was going to clarify, because it's very, very easy in this case to get confused. The CAT dealt with something very different. The CAT said the counterfactual is settlement at par, but then said, even though there's settlement at par, merchants will, out of the generosity of their hearts, etc., agree bilateral interchange fees above the default. So their counterfactual was still a rule settlement at par, but they thought people would bilaterally negotiate away from it.
Nobody supported that.
Well, and evidentially there were problems with it, and we appealed against it successfully, and the Court of Appeal rejected it.
Yeah.
But it's important to emphasise, and this is again the point that's made in the judgment, I think it's paragraph, point that's made in the judgment, which is that the CAT's bilateral counterfactual is not the same as Mastercard's, because ours is a what I call pure bilateral counterfactual, no rules, do your best, whereas the CAT were presuming settlement at par, but then thought people would have the ability or would have the willingness to negotiate away from it.
But the point you were making was about the AAM case, where
Yes, so in the AAM case,
there was some
yes, there were about a dozen or so, maybe more, I might be exaggerating, but certainly sort of 6 to 10 other possible counterfactuals considered. And the question in many cases were, are they actually any different or not? One of those was, and this is at the judgment at 46, was the pure bilaterals counterfactual, and that was dismissed by Mr. Justice Popperwell, and this bit wasn't overturned by anybody, it wasn't challenged, on the basis of the hold-up problem leads to collapse. And that then brings us before the Court of Appeal in Sainsbury's, which does establish the counterfactual, but in circumstances where nobody was saying that pure bilaterals was possible because of the hold-up problem and the collapse issue. So again, that was something that was factually considered, but just simply dismissed on the evidence as a result of that factual analysis.
I haven't understood why, pure bilaterals gives rise to a hold-up problem. I thought it was a free riding problem.
Well, the pure bilaterals allowed in a world in which you don't have the IFR is essentially a situation where issuers will then will have a certain amount of power, and will try and go higher. And it's a competitive situation where every one of them thinks, well, if I just make a bit more money, and then I'll make a bit more money, and then suddenly you end up with an MSC which is 5% or 10%, and then it collapses because merchants say, that's it, we've had enough. But it's almost the sort of prisoner's dilemma. Every individual issuer has an incentive to squeeze a little bit more out.
So it is a hold-up problem.
It is a hold-up problem.
Yeah. Which then results in collapse.
So in the Court of Appeal, considering the no or the zero MIF
Yes,
settlement part.
because by that point, all of the other options had fallen away on the facts. And then proposition 4 is that following the IFR, there are other options available which, 1, remove the measures in question, 2, would allow the scheme to survive without a MIF, and 3 are realistic alternatives. As a matter of fact, we say the Mastercard Bilateral's counterfactual is one of those. And certainly in terms of, for the summary judgment standard, it's accepted it's realistic, evidentially at least. It removes the UK MIF, and it doesn't endanger the scheme because it's not going to push rates up beyond the IFR caps, because people aren't allowed to do so. And then proposition 5, which is, as a consequence of all of that, the only way for the claimants to succeed is to show that the only lawful way Mastercard could operate in the absence of a MIF is by settlement at par. And that's essentially, she has to show that, I would expect Ms. Smith has to show that everything else, in particular the bilateral's counterfactual, is unlawful, because it's likely, it's realistic, and therefore the only reason we can strike it through is if it's in itself unlawful. And I think at various points Ms. Smith came close to accepting that must be the logic of, if she's wrong on the sort of the Supreme Court arguments, that must be the logic of where she goes on those points. And we do say that's right. She has to exclude everything else.
The Supreme Court has effectively closed this off.
Indeed.
But if she's wrong about that, then that would follow, wouldn't it? Because the only way in which claimants could succeed is if settlement of par and zero miss is the only lawful counterfactual.
Yes. And more significantly at this stage, she needs to show that essentially nothing else is even arguably lawful, which is the other problem that I would say in the context of a summary judgment hearing that she faces. So those are what I say are the sort of the 5 key propositions, and that brings me then to Mastercard's bilateral counterfactual. And as you've heard before, in its common ground, the way that bilateral's counterfactual operated is Mastercard would simply set no default settlement rules of any kind, leaving issuers and acquirers to negotiate bilaterally, completely freely, but obviously in the context of the regulation, which prohibits anything above the IFR caps. The regulation applies to bilaterals as well. So it's not a case, as at various times Ms. Smith were referred to, of Mastercard replacing one rule with another rule. We are removing the default settlement rules entirely. And I say, in a nutshell, that is why that is an entirely proper counterfactual. Mastercard is doing nothing, and so that cannot be a restriction of competition, because there's nothing being done collectively at all. And
You say completely freely, but in fact, Ms. Smith's point is it's constrained by the other features of this very peculiar market, namely the honour all cards rule and the fact that there are incentives. The issuers have to charge as much as they can up to the cap, and the acquirers don't really have incentives not to. So they're not entirely free. They're constrained by all sorts of other forces. Your point is that it's not you setting a rule.
There's no collectively imposed constraints. I'll obviously come to, as you rightly observe, my lord, there are 2 separate features here. And that's certainly what our evidence, and the evidence Dr. Neil shows, is there's a question of the motivations or the commercial imperatives of issuers and acquirers that exist regardless of the honourable cards rule. But with respect, that's going to be true in any world, that there will be commercial imperatives. And I think many people in the room may at one time or another have been bruised by the mobile phone termination cases. And that was the situation where mobile phone companies would charge a lot of money to fixed line operators ringing a mobile phone, which used to be very expensive, because their motivation was to try and extract money from that group of customers to ensure they could provide their direct customers more cheaply. Any 2-sided market, you have to decide which group of customers pays a different amount. So that's just inherent in having more than one group of customers, that you will try and do that. So to that extent, that is commercial competition, essentially. In terms of the honourable
The critical point here is you say there is no, or at least arguably, because we're dealing with summary judgment, there is no agreement or concerted practice which is restricting competition.
Absolutely.
So if there are restrictions on competition of the kind that my lord identifies, that's not down to the Mastercard rules on this hypothetical.
Yes, my lord. I mean, to some extent, some of what we're describing, I would just say simply that that is the nature of people competing.
Well,
yes,
I mean, we could argue about whether it's anti-competitive or competitive, but the critical question is it's not down to you, if I put it that way.
That's probably the best way of putting it, my lord. It's not, if it's not my fault, I don't mind. Yes, so essentially what that leads to is Ms. Smith basically having to sort of acknowledge that because there are no settlement rules, in order to find something collective, I know she has an argument about sort of some shared mutual understanding, which I can address very briefly in a moment, that she essentially falls back on the honourable cards rule. And I can deal with that very briefly. I mean, the honourable cards rule is not the measures in question. It's not one of the measures in question, at least for the purposes of this summary judgment application. And you know, essentially she has to exclude the honourable cards rule to say it's an unlawful counterfactual. And for these purposes, it may be at trial she can pursue that claim. Today, before this court, with respect, she simply cannot. You know, I mean, just very briefly, there was no argument below. The argument, in fact, was
doesn't
stayed.
claim to persuade us that the honourable cards rule is in breach of Article 101. I mean, that's quite clear. That's not her case. Her case is there's no relevant distinction between this case and the first wave. And either she's right about that or she's wrong about that.
Yeah, but we say, but you know, but once you basically acknowledge that, at the very least, it's arguable that our counterfactual is lawful, then you know, for the purpose of a summary judgment hearing, we simply pass on to the next stage. We have to deal with it on the basis of the evidence. So now, what is said somewhat differently, and this is where we get the ground 1B point, is the way it is put is the argument that there was some kind of mutual understanding between the parties. I mean, the short answer, of course, is you know, the CAT evaluated that based on the evidence and concluded that there was no scope to reach some kind of summary judgment level degree of finding on that. And with respect, that clearly must be right. We addressed it in detail in my skeleton argument at paragraphs 65 to 73, and just very briefly so you have the points. The relevant test is a mutual understanding which inhibits the freedom to determine conduct independently. They don't assert, let alone substantiate, you know, there's some restriction on independent conduct by issuers or acquirers. They can act independently, they will. The fact they may end up in the same place independently is, you know, neither here nor there. There's no evidence to support the idea is there's some kind of mutual understanding involving issuers or acquirers. Mastercard might have an expectation of where this would go, but no suggestion that's going to be mutually reached with issuers or acquirers. And there's simply no...
They all end up in the same place. It's neither here nor there, and that's what the Woodcock case says.
Absolutely, my lord. That's, you know, independent parallelism is always possible. So, yeah, I mean, simply for the summary judgment standard, there's simply no scope you know, for which any form of findings on those issues or to challenge the tribunal's view on it. So we say simply the bilateral's counterfactual is arguably lawful. Therefore, I mean, for present purposes, you know, there's simply no scope to say there should be summary judgment in relation to the post-IFR.
Yep.
Unless there's anything I can assist on in grounds 1A and 1B, and that's all I was planning to add in relation to those issues, my lords. And then that brings me to the interregional fees. I mean, again, Mr. Kennelly stole a fair amount of my thunder in relation to this, but a few brief points. I mean, firstly, the relevant appeal standard, which is the point I pick up paragraph 16 to 19 of my skeleton argument, because the argument, or it's advanced in the skeleton on the basis the tribunal was wrong within the meaning of CPR 52.21, there is no general right of appeal from the Competition Appeal Tribunal.
It's issues of law alone.
Issues of law alone. And I say ground 2 is about as far from issues of law for these purposes as possible. I mean, it is the tribunal's evaluation of evidence and whether or not it reaches the summary judgment standard. And I very much take the point made by Lord Justice Nugee. There's no findings of fact.
By an expert tribunal, which this court has said more than once in the recent past is somewhere where the Court of Appeal won't go.
My lord, and that is the submission. So regardless of anything else, it's simply these are the kind of points that should not be touched. You said it's multifactorial. It's anticipating the kind of evidence that might come out, which is always the classic of the summary judgment standard in a case like this, which is taking place prior to disclosure, witness evidence, expert reports. As Mr. Kennelly said, in circumstances where the entire or all of the negotiations between acquirers and merchants, to the extent that anyone in the room knows anything about it, it's the 1,000 claimants who have those interactions, not the schemes who know nothing about the confidential dealings between acquirers and merchants. So we simply say this is just not the kind of matter that is suitable for an appeal to this court from this tribunal. Again, next.
I mean, even though an appeal only lies on a point of law, you cannot presumably appeal a refusal of summary judgment if there's only one proper conclusion available on the factual evidence before the tribunal.
Well, firstly, I acknowledge you can appeal a refusal of summary judgment, and clearly, and I think the recent judgment of this court in BT versus Bilateral makes the point, and that's in the bundle, but it does make the point that there are times when, if you evaluate the facts and reach, an outcome that is simply so far beyond the remit of what's possible. I mean, that's a sort of judicial review standard of error of law. So
outside the broad range of
yeah,
possible outcomes.
absolutely. So. And obviously, the more multifactorial it is, the more balancing exercise it is, all those matters, the more difficult it is for this court to say, essentially, that is something that no reasonable judge could have concluded. But yes, there is that almost Wednesbury unreasonable standard that applies, and that would still be a point of law. But I mean, really, that's not what's being said here. It's a disagreement about exactly what the factual findings were. Next point is then appreciability. Now, as Mr. Kennelly explained, the tribunal essentially said they wouldn't grant summary judgment, making 2 points. One was the need to examine this as a matter of fact, and matters like the floor effect. And the conclusion on that is paragraph 67. And the next one is the need to show appreciability, and that's paragraph 68, and there simply wasn't evidence on that. One point I wanted to emphasise is that there is no attempt in the grounds of appeal or the skeleton argument to challenge the tribunal's conclusion that the claimants had not established appreciability. And I mean, it must follow that they didn't establish appreciability because they put forward no evidence of any kind, substantive evidence of any kind, and certainly no substantive of any kind that would have gone to appreciability. And with respect, there was no attempt again made in my learned friend's oral submissions to address appreciability at all, or that finding. So we have a judgment which was reached for 2 reasons. The first one of those reasons is challenged, the second is not. Again, we say that necessarily follows that the tribunal's judgment cannot be overturned. And what I also say in relation to that is appreciability is quintessentially one of those things that can only be dealt with on the basis of the evidence. Now, clearly there'll be circumstances where it is so obvious that either it's admitted or it's either admitted or it's so profound that it's obvious. The classic sort of price-fixing cartel. It may very well be obvious. But where this is being dealt with, in the Commission decision, for example, and that's, again, the extract was added, but I think, again, the specifics of it don't matter very much. What the Commission did is look at the share of transactions covered by the EEA MIF in each of at the time, the 25 members of the European Union. So they actually, again, grappled with the point in order to see that there were some countries where the EEA MIF applied to a considerable, is their word, number of transactions. But here we're dealing with something that applies to a very small number of transactions at certain kinds of merchants. So it essentially begs the question. It needs to be dealt with on the basis of evidence. CAT found there was no evidence. That's obviously right. They clearly couldn't establish that appreciability with a complete void on the relevant issue. Next is what said are the admissions made by Mastercard. And in relation to that, it's 2 paragraphs of our defence, paragraph 35E and 47, Again, I'd say these simply don't take the claimants anywhere. That what we said firstly is we acknowledge that in negotiating merchant service charges, acquirers will take account of their costs. Well, it's one relevant consideration. They're obviously not going to be blind to their costs. Whether that actually makes a difference to the price is an entirely different question. That's a factual question. That's certainly not an acknowledgement that it will in fact have an effect, still less that one very small element of cost like interregional MIFs will in fact have an effect, still less an appreciable effect. And the other thing we said is that fees paid by acquirers may impact on the level of the MSC. They may. I mean, that's, but it's the question of they have to prove they do. Yes, they may.
May not.
Absolutely, my lord. And again, may doesn't mean that every single one, regardless of how small it is, such a small proportion of transactions will. So neither of those are admissions that help my learned friend in any way at all. I've also put before the tribunal, for this court, the payment systems regulator's final report, the extracts on that. I mean, this ultimately may not take the court very far on the basis that you've seen. Essentially, our point here is, the point by both schemes is these are factual matters. I rely upon the payment system regulator's report as an indication of a kind of evidence that might be expected to be available at trial. And because it shows that even after the IFR cuts to domestic interchange fees, there was little or no pass-through of those reductions for most merchants, both small and medium merchants, and that was people with annual card turnovers up to 10 million, and also large merchants with turnovers of between 10 and 20 and 50 million. So even though we're talking there about the dominant interchange fee, the domestic and cross-border ones, and very substantial cuts, there was essentially no evidence the MSCs ended up being different as a result of that. And what I rely upon that just simply to show it's not obvious that in that acquiring market, that changes to interchange fees will actually result in changes to MSCs for the vast majority of merchants. Now, interchange plus, of course, it mechanically works its way through. Again, there's no evidence to suggest that the very small number of merchants who have interchange fee plus arrangements have substantial amounts of interregional cards, or actually that it makes any real difference to competition if there's such a tiny proportion of business. And the kind of merchants that have it are the Tesco, the Sainsbury's, that obviously we know about from previous cases. Again, not the kind of people who get a great deal of Chinese businessmen shopping on Bond Street and popping to Tesco for a sandwich as well. That's not I would imagine, a very large proportion of their turnover. Yeah. So again, it's simply an illustration of the fact that these are factual points that one needs to address. The final point that I was going to deal with was ancillary restraint.
Yes.
And in relation to this, so we both disputed that the interregional MIFs restricted competition. We also opposed the application for summary judgment on the basis that it was arguable, again on the summary judgment standard, that interregional MIFs were a lawful ancillary restraint because they were objectively necessary for the operation of an interregional four-party payment card scheme. Now, because we won on the first point, the tribunal concluded it was arguable, the tribunal concluded it didn't need to consider the second point. And I essentially say the same thing to this court, which is you only need to get into this if you're against me on the first point. But if you are against us on the first point, then I do invite the court to look at this and conclude that summary judgment could also not be, or shouldn't have been granted for this reason, because there is an arguable case of ancillary restraint. Again, for the same points, that it is a factual matter that simply cannot be dismissed before one gets in to the detailed evidence. And in terms of objective necessity, my lord, the Chancellor suggested, again on day one, that it was common ground before the Court of Appeal in Sainsbury's that it was not necessary to have an interchange fee for a four-party payment card scheme to operate. And my lord is right to say that it was common ground in the context of those proceedings which were concerned with consumer cards in the UK and Ireland. we don't say that that isn't correct as a matter of a universal position, regardless of the product. Commercial cards being a good example, they're not before this court, but they were before the tribunal below. Regardless of the geographic market, Italian MIFs were before the tribunal below, not before this court, or then interregional. And we say once you look at a different product, either different product
How
or a
does it
different
work then?
geographic market, then you actually have to look at each one to see if there is a commercial need for it. Can you do it viably?
How does it work here? What's the distinction that you seek to draw between what was common ground in Mastercard and Visa domestic,
Well,
through AEA context, but isn't for interregional?
in the interregional context, I mean, probably the most important feature, and there are a couple of ones, but one is the number of other players out there that, as I said before, when one's talking about interregional, where we're talking about interregional MIFs resulting in MSCs in the UK, we're talking about a product that's being offered to Japanese cardholders, Chinese cardholders, Australians, Americans, all those kind of categories. And in those circumstances, one does face a much greater range of competitors than one does in the UK market. And also in the context of that kind of interregional, international business, even players like Amex that do feature in the domestic market are much bigger players. They have a much more substantial market share, so they are more of a threat. And the issue that arose in the Sainsbury's case was that we acknowledged that we would not lose 100% of our business to Amex if we didn't operate without interchange fees. We said we'd lose it all to Visa. The Court of Appeal said, no, that's asymmetric. They're the same as you. You can't rely upon Visa. But it's not been suggested we couldn't rely upon switching to Amex. It just wasn't going to take place at the kind of levels that would endanger our business. And we say here that when you're looking in a whole variety of international markets where there are lots of other players, including players like Amex who are at a much bigger market share and a much greater threat for this kind of international businessman kind of travel, where that is Amex's kind of raison d'etre, essentially, that is a threat, and that does prevent, that is something that needs to be considered on the evidence properly.
Sorry, I'm not following at the moment how the availability of high interregional MIFs prevents that threat of competition from Amex. How does that work?
Well, it works in the same way these arguments always work, which is on the basis that unless we can provide revenue to a Japanese bank issuing a Mastercard card, it will.
So it's
either.
Is that if the issuers haven't got the incentive through the MIFs, then they're likely to drift off and
They'll either issue somebody
Amex
else.
cards or somebody else's cards instead.
Well, either the issuers will or the cardholders will. Because if the cardholders are in a position where 100% of the costs, and again, points Mr. Kennelly made, like fraud costs are very high for interregional points like this, if you're trying to recover 100% of the costs from cardholders, and one's more familiar with, as a cardholder, being exposed to charges, not necessarily ways that are obvious to you, but certainly things like currency conversion and points like this. If it's obvious that you're getting an incredibly bad rate of exchange if you use a Mastercard, but if you use an Alipay, then you're getting a much better rate of exchange. Then people will vote with their feet. So that's what we say is the potential mechanism for this. That's what the evidence goes towards. And I mean, what's said in answer to this point is not that our evidence isn't good enough on a summary judgment basis, but essentially that this is legally wrong. And those are the points that are put back against me. And so to pick them up, it's the supplemental skeleton argument from the appellants, which is core bundle tab 13 at page 268. there's no reference to any of our evidence not being good enough, not reaching a standard or whatever else. The 2 points that are made at paragraphs, essentially it's paragraph 7 and 8, so paragraph 9 is then the conclusion, is firstly says that the objective necessity argument should be refused. The argument's misconceived because Mastercard seeks to treat each different type of MIF as giving rise to a separate payment scheme, when in fact they're just different price levels imposed under one four-party payment scheme. We say with respect that's just simply wrong. The critical thing is whether the main operation could survive. And you have to ask in the context of this, as a matter of both market definition, product definition, and also geographic definition, what is the main operation? And if you're talking about operating a scheme which is designed to provide inter-regional usage to Japanese cardholders, for example, Australian cardholders, that is the operation that you're trying to operate. And if you don't have a competitive pricing structure, you are simply not going to be able to operate that main operation. And we say what's wrong here is failing to recognise that the main operation each time is separate. And effectively, my learned friend's argument amounts to saying, well, you might need this restriction to produce a car, but it's not necessary because you can produce a bike instead. And that's just not good enough. What we're trying to produce in this context is something that is a product that is an international product. And there are a whole variety of products which are standalone international products, like electronic wallets that allow for currency exchange, that we are competing with. And we need to produce that product which is attractive to a certain group of customers in different countries. We need to be competitive. And to essentially say, Mastercard could operate a domestic UK scheme without a MIF, because that's what the Court of Appeal concluded as a matter of objective necessity applied in Sainsbury's. With respect, we say that's just simply neither here nor there. It tells you nothing about the operation actually in question. And that's particularly when it comes to inter-regional. These are often separate markets, and these are all matters that are arguable. These are arguably separate markets. These are arguably a separate group of customers in another region. It faces, again, arguably a whole separate group of competitors. And they said the end result of that is these are arguably distinct products, distinct geographic markets, and that is the main operation. And then the next point is paragraph 8, my learned friend's response skeleton, which refers to the Court of Appeal judgment in Sainsbury's. It's quoted there, paragraph 200. Without the restriction of a default MIF, this type of main operation, namely a four-party card scheme, could survive. The short answer to that question is the affirmative. The contrary was not suggested by Mastercard at VISA. There are a number of other schemes in other parts of the world that operate perfectly satisfactorily without any default MIF and only a settlement of par rule. But that records what was at issue in that case. And it was not in dispute in that case that once we had lost the asymmetric counterfactual, as we did, that we didn't have an argument or objective necessity because a domestic Mastercard scheme would survive based on a threat from Amex and PayPal. That is simply, we say, that doesn't follow evidentially in relation to a variety of other countries and offering something inter-regional. So we say that doesn't take matters any further. The fact that a small number of schemes in other parts of the world have in the past operated, again, that simply tells you market conditions in different product or geographic markets may be different. So again, these points we say simply just don't take the court anywhere in saying essentially it's closed off to us to establish on the evidence that a different product does require something different for objective necessity.
Is this a variant of a death spiral argument in relation to the international market? If you can't charge inter-regional MIFs, but other people in other countries can, you lose business to them until eventually you have no business left.
Sorry, it is. I'm afraid I struggle with the term death spiral because that's actually a complete.
Well, it's a different, point, though, isn't it? Because the point about the death spiral argument, the reason why the death spiral argument failed was because it was about the position of Mastercard and Visa, and you couldn't say that you couldn't, as it were, set a counterfactual for Mastercard, which assumed that Visa was still able to pursue its scheme in an entirely what would in fact be an entirely unlawful way. But if what you're talking about is other people, other schemes in other jurisdictions competing, we just don't know whether those schemes are lawful under their local laws or not. They may or may not be. So it's not the same, not exactly the same issue.
Yeah, I mean, my hesitation, Lord Nugee, would only that it became a term of art, the death spiral, in relation to a particular argument here. It is, in essence, an argument that says Mastercard could not operate in a way that's commercial and would therefore essentially have no business. So it is that
You'd
argument.
end up just being a domestic provider.
Well,
Yes,
yes, I mean, bear in mind that this is only international, sort of interregional. So it
Domestic
only
and
applies.
European, yes.
Yeah, so we might still have a whole European business, we might still have a whole American business, but that simply in terms of international travellers wanting to go, classically the big spenders are going to be a small number of very wealthy people, or businessmen, those people who are looking at what's the best way to basically go and spend money in Bond Street, that they're not going to be using us, and simply we lose that functionality and that anyone wanting to use this for that purpose. And that's significant. What is significant here is the fact that in a number of markets, Mastercard essentially is only a cross-border product, and Mastercard's been an add-on to a number of domestic schemes who have basically the domestic scheme is, and this used to be the case if one thinks back to Access, which was the precursor to Mastercard. Access was the British domestic product. Mastercard was on the back of the card only for international acceptance, and that's not uncommon in a number of other jurisdictions where they have a domestic product and you simply get the Mastercard logo to be used elsewhere. And that's simply, if we're not commercially viable for that, which is essentially our only product element there, is the international acceptance.
Well, there was a time when it wasn't even on the back of the card. You could only use an access card in this jurisdiction.
Oh, absolutely. If one goes back long enough, you start off with just a domestic.
You had to have either Amex or Diners Club if you wanted to use a card in Europe. I can remember going to Europe when we were first married a long time ago, and I didn't have a credit card other than the one, whichever one it was. We had to wait till I had to find a cash till in order to take money out. So,
Start telling you about traveller's checks as well, my lord. Yes. So, yeah, I mean, there were, historically a number of, but certainly in terms of, and now sort of the other way, which is there are a whole variety of purely electronic competitors and things like that out there. We're not looking simply at card-based competitors. Yeah. So it's moved on again. But all of these points we say go to, we are fighting in a different market with a different product. And unless we can be competitive,
well, that's your
we'll
point
have no business.
as to why resort to what was said by the Court of Appeal in the earlier case doesn't really help, because it just wasn't dealing, we just weren't dealing with these sorts of issues.
Absolutely, my lord. So we say in relation to that, this is ultimately a matter that goes to the evidence, and the only argument against me is effectively that we never get to the evidence because it's inherently wrong. I say that it's not, and on that basis our evidence is good enough, and that's a further reason why summary judgment should not have been granted. My lords, unless I can assist you further, that's me done for the day. Well, maybe not today.
Well, that brings us pretty much to 4:15, really.
Yes, I would, in light of that, I think there's plenty of time for me to reply tomorrow. I think that would probably be most efficient, because overnight I can make sure that my reply
I
is
wasn't going to
focused.
ask you to start.
For the last 3 minutes.
3 minutes.
My lord.
Right, well, we'll adjourn till 10:30.
No, as I mentioned, if I may, very briefly, I mentioned a letter we gave the tribunal on this question about the MSC, where I had momentarily forgotten the fact that the MSC included within it not just Visa, Mastercard, but also in some situations Amex and the rest.
Thank you.
But those behind me have retrieved it. It was a letter the tribunal asked, and we sent it to them, and I have a copy for the claimants. We'll email, obviously, now, friends, a bit more. I'll give this to the now, no doubt it can be addressed tomorrow. It's the the only relevant page, the very last page of this letter.
Right.
I made no submissions on it, it's self-evident on its own face.
Thank you very much. Let me just quickly look at that. Yeah, okay, that's very helpful, thank you. Right. Okay, well, we'll adjourn till 10:30 tomorrow morning. We're assuming that notwithstanding the rail strikes, we're going to continue in court. I don't know if there are going to be any disruptions from the point of view. I think I was told that I think I gave permission for Office 2 to assist us remotely tomorrow, which I understand they can do. But subject to that, we're assuming everybody's in a position to attend tomorrow. All right, so we see you at 10:30 tomorrow.
Oh, rise. They see it.